Welcome to the channel and welcome to episode 87 on the Law Report. Today I'm going to deal with a subject that is not really within my specialty, and that subject is the law on trademarks in the Turks and Caicos Islands. I was asked a few questions on this subject by a viewer of this channel, and while this is not my area of law, I decided to do an episode which would only be confined to the basics in trademark law. I do hope that I do justice to the topic. I'll be back shortly to explore this topic, but before I do, my usual disclaimer: this is not legal advice, should not be construed as legal advice. For legal advice, please contact competent attorney in this area of law. Welcome back. Trademark law is an essential aspect of intellectual property law the world over and governs the protection of distinctive signs, symbols, and much more, such as logos, brand names, products, and designs. In the Turks and Caicos Islands, the Trademark Ordinance governs and regulates the law around trademarks. Trademark protection in the Turks and Caicos Islands is granted through registration with the Registrar of Trademarks. Once registered, a trademark owner has the exclusive rights to use that trademark in relation to the goods or services for which it is registered. This means that no other business can use a similar trademark that is likely to cause confusion to customers or affect in any significant way the distinctiveness of the registered trademark. It appears from the ordinance that trademarks can include words, slogans, logos, designs, songs, and perhaps it can even be extended to smells. So let's look briefly at the law surrounding trademarks, and let us dive into the Trademarks Ordinance of the Turks and Caicos Islands. By virtue of Section 11 of the Ordinance, an application can be made to the registrar, and for the purposes of the Ordinance, the registrar means the Registrar of Trademarks, Certification Marks, and Collective Marks. An application for a trademark to be registered shall contain a request for registration of a trademark, B, the name and address of the applicant, C, the name and address of the appointed agent, D, a statement of the goods or services in relation to which it is sought to register the trademark, E, the classification of the goods or services, and F, a representation of the trademark. According to Section 11, subsection 3, the application shall state that the trademark is being used by the applicant or with his consent in relation to those goods and services, or that he has a bona fide intention that it should be used. The application, by virtue of subsection 4 of section 11, is subject to payment of an application fee and such class fee as the registrar thinks fit. Section 15 deals with the proceedings and observations. Section 15.1, when an application for registration has been accepted, the registrar shall cause the application to be published in the Gazette in the prescribed manner. Any person may within 1 month from the date of the publication of the application give notice to the registrar of his or her opposition to the registration. The notice shall be given in writing in the prescribed manner and shall include a statement of the grounds of opposition. Where an application has been published, any person at any time before registration of the trademark may make observations in writing to the registrar as to whether the trademark should be registered, and the registrar shall inform the applicant of any such observation. A person who makes an observation does not hereby become a party to the proceedings on the application. Section 17 of the ordinance deals with the registration. So where an application has been accepted and a notice of opposition is given within the period referred to in section 15 subsection 2, or all opposition proceedings are withdrawn or decided in favor of the applicant, the registrar shall register the trademark unless it appears to him, having regard to matters coming to his notice since he accepted the application, that it was accepted in error. Section 17 subsection 2 states, a trademark shall not be registered unless the prescribed fees for the application and registration are paid within the prescribed period. And if the fees are not paid within that period, the application shall be deemed to be withdrawn. Subsection 3 states that a trademark, when registered, shall be registered as of the date of filing of the application for registration, and that date shall be deemed for the purpose of the ordinance to be the date of registration. Section 19 of the Trademarks Ordinance deals with duration, renewal of annual fees, and alteration of registered trademark. So, Section 19 subsection 1 states that a trademark shall be registered for a period of 10 years from the date of registration. Registration may be renewed in accordance with Section 20 for the periods of 10 years. Section 20 of the ordinance deals with renewal of registration. Subsection 1 of Section 20 states that the registration of a trademark may be renewed at the request of the proprietor, subject to payment of the prescribed renewal fee. Subsection 1 of Section 21 deals with annual fees and default of payment is dealt with at subsection 2 of Section 21. So Section 21 subsection 1 states that the proprietor of a trademark recorded in the registry must on the 1st of January of each year pay the registrar the annual fee prescribed. And bearing in mind that the 1st of January is traditionally New Year's Day and a public holiday, I believe that the fee would fall due on the 2nd, which is the first working day immediately after the public holiday. Subsection 2 deals with default. Default in payment of the annual fee for more than 1 month causes the right protected by the recorded entry to be in abeyance as against the person in default from the relevant period, which is the 1st of January, until the fee is paid. Section 24 deals with the rights conferred by registered trademark. Section 24 subsection 1 states that subject to the provision of this ordinance, the proprietor of a registered trademark has exclusive rights in the trademark which are infringed by use of the trademark in the islands without his consent. Subsection 2 of Section 24 states that the acts amounting to infringement, if done without the consent of the proprietor, are specified in Section 25. So let's look at Section 25, which states that a person infringes a registered trademark if he uses in the course of trade a sign or mark which is identical with the trademark and is used in relation to goods or services which are identical with those for which it is registered. Subsection 2 states that a person infringes a registered trademark if he uses in the course of a trade a sign where A, the sign is identical with the trademark and is used in relation to goods or services similar to those for which the trademark is registered. B, the sign is similar to the trademark and is used in relation to goods or services identical with or similar to those for which the trademark is registered. Or C, there exists a likelihood of confusion on the part of the public, which includes the likelihood of association with the trademark. Subsection 3 of Section 25 states that a person infringes a registered trademark if he uses in the course of a trade a sign which A, is identical with or similar to the trademark, and B, is used in relation to goods or services which are similar for those which the trademark is registered, where the trademark has a repetition in the United Kingdom, the European Union, or the islands, and the use of the sign being without due cause takes unfair advantage of or is detrimental to the distinctive character of the repute of the trademark. Section 36 deals with specially protected emblems. So Section 36A describe specially protected emblems as national flags, insignia of royalty and international organization, and coat of arms. B. Words, letters, or devices likely to lead a person to think that the applicant either has or recently has had government patronage or authorization, and these shall not be registered unless it appears to the registrar that consent has been given by or on behalf of the government. Subsection 2 of Section 36 states that a trademark shall not be registered if it falls in one of the categories referred to in Section 63 or Section 62, and Section 62 deals with national emblems, and Section 63 deals with emblems of certain international organizations, etc. Section 37 of the Trademarks Ordinance deals with grounds for refusal of registration. So, subsection 1 of Section 37 states that a trademark shall not be registered if it is identical with an earlier trademark and the goods and services for which the trademark is applied for are identical with the goods or services for which the earlier trademark is protected. Subsection 2 states that a trademark shall not be registered if A. It is identical with an earlier trademark and is to be registered for goods or services similar to those for which the earlier trademark is protected, or B. It is similar to an earlier trademark and is to be registered for goods and services identical with or similar to those for which the earlier trademark is protected, and there exists a likelihood of confusion on the part of the public, which includes a likelihood of association with the earlier trademark. Section 45 deals with the revocation of trademarks. Section 49 deals with actions for infringement. An action for infringement of a trademark is actionable by the proprietor of the trademark. In an action for infringement, all such relief by way of damages, injunction, accounts, or otherwise is available to him, as is available in respect of the infringement of any other property right. So the registered proprietor of a trademark can bring an action in the court, in the Supreme Court of the Turks and Caicos Islands, against a person who infringes on his or her trademark and seek damages or injunctions against the person using or the person infringing on the trademark. Sections 75 and 76 set out criminal offenses in relation to trademarks. So Section 75 deals with falsification of the register, and it states that it's an offense for a person to make a cause to be made a false entry in the register of trademarks, knowing or having reason to believe that it is false, and a person commits such an offence shall be liable on summary conviction to a fine of 5,000 or to a term of imprisonment of 3 years or to both a fine and imprisonment. And section 76 deals with falsely representing trademarks as registered. And it is an offence, it states, for a person to represent that a trademark is registered or to make a false representation as to the goods and services for which the trademark is registered. And the person who commits an offence under this section, section 76, shall be liable on summary conviction to a fine of 5,000 or to a term of imprisonment of 2 years or to both fine and imprisonment. Here is where I'm going to leave this episode for today. I hope that I have done justice to the episode. I hope that the person who asks me to deal with this topic is satisfied. If not, they could always leave a comment in the comment section below, and I will try to expand or clarify. But yes, trademarks can be registered in the Turks and Caicos Islands. They are protected in the Turks and Caicos Islands, and we have an ordinance in the Turks and Caicos Islands that deals with the registration, the criteria, and the regulations. If you have learned anything from this episode, please like, please share, and I will see you very shortly in episode 88. Thank you for watching.